So the Supreme Court has denied review of a Second Amendment case which would have expanded a prior unanimous decision involving firearms confiscations. So let's talk about this. But real quick before we jump into this video, if you think it's time for the Supreme Court to once again uphold our right to keep and bear arms, go ahead and hit that like button and subscribe. Also, I want to give a shout out to one of the main supporters of this channel, which is USCCA. Through your membership, you get training, education, and self-defense liability protection. And right now, if you sign up with USCCA, you can actually get some things along with your subscription. For example, in the month of January, you can get something like the survival kit. They are offering Pelican cases as well. Some backpacks, bags, duffel bags, a ton of things. So it really depends on what subscription model you get, what membership you get. So if you're interested in something like that, I will leave a link down below to USCCA. And thank you again to USCCA for sponsoring this video. As I mentioned in the intro, in this video, we will be discussing a Second Amendment and Fourth Amendment case, which was just denied review by the Supreme Court. The case we're going to be talking about in this video is called Greco v. Platkin, and it was a challenge to the state of New Jersey's extreme risk protection orders, also known as red flag laws. This case provided an interesting opportunity for the Supreme Court to revisit an issue of red flag laws and also the unlawful search and seizure of firearms. One of the questions after a recent Supreme Court unanimous decision in the case called Coniglia v. Strom was whether or not the Supreme Court would eventually take up a challenge to red flag laws and ultimately decide to strike them down. Well, with this recent denial, the answer to that question appears to be no, at least not for right now. So the facts surrounding this challenge are as follows. This case arises out of a 2019 incident where law enforcement received an extreme risk protection order against an individual named David Greco, who was a 51-year-old man who had been posting anti-Jewish commentary on various social media websites. The police had in fact been monitoring his activity for a while and first came into contact with him at his own home in August. Subsequent to that first visit, they received an order and obtained a no-knock warrant from the Superior Court judge that is involved in this case, which allowed them to enter his home and ultimately to seize his firearms and also his ammunition. This was all done as a result of a law that passed back in 2018 in the state of New Jersey, and that law was called the New Jersey Extreme Risk Protection Order Act. The state of New Jersey joined 17 other states which have similar laws, but the state of New Jersey took their law beyond what the other ones had already done. Typically in other states, when law enforcement is acting under the state's version of a red flag law, a court is presented with preliminary information in a civil complaint or petition alleging that the person who lawfully owns guns may be a danger to themselves or to others. If the state court is satisfied that the allegations may be true, the state court then enters an initial court order directing the person in question to show cause at a hearing or otherwise to voluntarily turn over his or her weapons. This type of scheme is clearly unlawful, but the state of New Jersey went even further than other states. New Jersey's version of this law creates a structure where at the initial complaint and petition stage, and at the beginning of all these proceedings, they will use the lower legal standard of good cause instead of probable cause. That lower standard of good cause is then used to determine whether to issue a temporary emergency risk protection order and then activate the mandated automatic search warrant and also the automatic seizure of all firearms and ammunition. This means at the very beginning stage of the whole process, law enforcement become authorized to kick in a front door of a person of their home and forcibly seize that person's firearms and ammunition using only good cause as the rationale instead of probable cause. Now, before this law went into effect, on August 12, 2019, the New Jersey Administrative Office of the Courts issued a memo on the extreme risk protection orders and the act that was passed, and they openly acknowledged that the text of this law, as enacted, was in fact unconstitutional because it required the use of good cause instead of probable cause. Then the New Jersey Attorney General also issued a memo agreeing that the law's use of the good cause standard instead of probable cause was indeed unconstitutional. In fact, the district court who originally heard this lawsuit and during the initial arguments of the hearing actually said, and I'm going to quote what he said, he opened up by saying, "Okay, you could all be seated. Before we get started, could we agree for the purposes of this hearing that on its face, this law is unconstitutional?" To which the state attorneys actually responded, "Well, that's quite an opener, Your Honor." So the state at multiple levels agreed as written that this red flag law in the state of New Jersey was indeed unconstitutional. Even the district court judge who originally heard this case agreed at the very beginning that it was unconstitutional. How then did this eventually end up before the Supreme Court? Well, there were two issues that arose. First, the state argued that under the Younger v. Harris case, the court should abstain from hearing this specific case. Younger v. Harris was a 1971 case in which the Supreme Court held that federal courts were required to abstain from hearing any civil rights torts claims brought by a person who is currently being prosecuted for a matter arising from that specific claim. In a 8-1 decision, the Supreme Court held that federal courts may not hear the case until the person is convicted or found not guilty of the crime unless the defendant will suffer some sort of irreparable injury that is both great and immediate. However, in that same decision, the Supreme Court found that merely having to endure a criminal prosecution is no such irreparable harm. Abstaining was the first defense raised by the state of New Jersey, and then they also argue that the memo that was sent out telling the courts to not actually follow the text of the law, but instead to use probable cause instead of good cause, was a sufficient enough of a fix. Multiple times during the initial case, the district court judge rejected the whole Younger abstention requests by that state. However, 14 months into the case, all of a sudden the judge in the case had a change of heart and decided to grant the motion for summary judgment in favor of the state of New Jersey using that whole Younger abstention grounds. The plaintiff then appealed that decision up to the Third Circuit, who ultimately ruled in favor of the state of New Jersey, and now that case made its way up to the Supreme Court for their review. Greco was important because it could be the first case to springboard off of the Supreme Court's prior unanimous decision and their recent decision in the Caniglia v. Strom case. If you're not aware, last year the Supreme Court issued a ruling in a case called Caniglia v. Strom. That case dealt with whether law enforcement could use the excuse of community caretaking to search and seize firearms without a warrant or probable cause. In the Caniglia case, the state was trying to use rules which applied to vehicles and apply them to a search and seizure of firearms within a home. Justice Thomas, writing for the court, actually stated, "The Fourth Amendment protects the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. The very core of this guarantee is the right of a man to retreat into his own home and there be free from unreasonable governmental intrusions." Justice Thomas therefore found what is reasonable for vehicles is different from what is reasonable for homes. Based on this, the Supreme Court found that the warrantless entry into Mr. Caniglia's home and the seizure of his firearms was indeed unconstitutional. One of the big questions coming out of the Caniglia case and that unanimous decision was whether or not it would eventually impact red flag laws and whether or not the Supreme Court would eventually take up a red flag law case. Well, the answer to that appears to be that the Supreme Court right now is not interested in a red flag law case because we just received the order from the Supreme Court and they have in fact denied review in this Greco case. So they are not going to take up this red flag law confiscation case. But for now, it appears that the Supreme Court is not interested in a red flag law case and they have denied review in this Greco case. So if you guys have any questions, go ahead and comment down below and I will try to answer to the best of my ability. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm and it signals to YouTube that you guys see value in these videos and in this type of 2A news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars and this nation will be maintained by armed scholars.